So picture this, you're getting divorced, you and your spouse have a bunch of debts and you're absolutely confused over who's gonna have to pay which debts. Well, in today's video, I'm gonna clear up that confusion for you. See, one of the critical aspects that often takes center stage in divorces is how you're gonna divide up your debts. And in divorce, this division can occur either through an amicable agreement between the parties or, in more contentious cases, by decision of a judge or a jury during a trial. Now, there's two primary categories of debts when you're going through a divorce. There's marital debt and then there's separate debt. While everything may appear as joint obligations during the marriage, the divorce process untangles those debts and sometimes reclassifies debts as separate debts, meaning only one spouse is responsible for paying the debt. So consider assets like the marital home or maybe back taxes stemming from joint tax returns filed during the marriage. These are commonly acknowledged as straightforward marital debts. However, the waters can get pretty muddy when you're examining things like joint credit cards. Why is that? Well, because both partners perhaps may have used these cards for various family expenses, but with distinctive different spending patterns. So take a simplified example here. Two joint credit cards funded family necessities like groceries and car maintenance and vacations, while a third credit card was used exclusively by the husband for golf-related expenses, and perhaps a fourth card was used by the wife for work-related needs for her career. In this scenario I just painted for you, negotiations during the mediation or a court trial might lead to a decision to split the debt on the first two cards as marital debt, while the third and fourth cards could be considered separate debts of the husband and the wife respectively. Now, sometimes it can get even muddier than that when joint credit cards may also have expenses on them that were exclusively for the use of one party's benefit. For example, a work suit for the husband showing it was purchased perhaps at Brooks Brothers, or a ladies' weekend away for the wife with her friends showing airline tickets and hotel rooms and food purchases. Even though those examples of spending that were not in furtherance of the marriage appear on the joint credit card in my example, they can be easily identified and then recategorized and justified as separate debts that should be carried by the respective parties. That does bring me to a pretty good phrase that will help you identify in most cases how debts should be categorized. And that phrase is, in furtherance of the marriage. If you ask yourself whether a debt was for the benefit of the marriage rather than for one of the parties, you'll be able to pretty easily classify the debts as long as you're both fair about it. If you're not fair about it, you're going to end up wasting more time and money fighting over it in mediation or in court than it's worth. Speaking of which, you've heard the stories about people spending hundreds of dollars in attorney fees fighting over a dish, right? I've actually had that happen. I've seen that. I was in mediation one time where the parties spent 2 hours fighting over a fancy clothing dryer. And this happened in November when those dryers were on sale at places like Home Depot and Best Buy. And these parties not only paid their respective attorneys for the time they wasted fighting, they also paid the mediator. So they had 3 of us on the clock. They probably wasted $1,500 fighting over a $600 dryer. So yeah, these stories of craziness like this are real. It was a principle of it, they said, but principle can be pretty expensive stuff. So what I want you to take away here is that there is no one-size-fits-all formula for debt division and divorce. The process is inherently subjective and it hinges on negotiation or, if necessary, an equitable division as ordered by a court. By the way, equitable division, contrary to popular belief, does not mean equal division or an equal split. Equitable means fair, a fair split based upon the circumstances of the case. Equitable division takes into account the unique circumstances of each party involved. For instance, if one party earns significantly more than the other party, a fair division, an equitable division, might translate into a proportional sharing of the debt. This means that even if the division of the debt is not mathematically equal, it could still be considered equitable and in alignment with the principle of fairness in the eyes of the court. When going through the divorce process, well before getting into mediation or a court hearing or a trial, it is required that the parties disclose their financial situations fully to ensure a comprehensive understanding of the assets and the liabilities that are at play. So this transparency also fosters an environment where negotiations can occur with a foundation of trust and awareness. And then, if the attempts to reach settlement and agreement between the parties fail, in that case, at that point, the courts can then jump in and make the informed decisions that are necessary. But the point here is that there's no tolerance for hiding the ball. If you're preparing for divorce or starting down that road in a case, it's essential to be proactive in managing your financial affairs. Begin compiling a detailed list of all the assets and debts that were accrued during the marriage, because this inventory will serve as a crucial reference point during negotiations or during court proceedings. Knowledge is really powerful in a legal case, and the more informed you are about your financial situation, the better equipped you'll be to navigate through the debt division. It's important to realize that the divorce is not just a legal process, but it's a deeply personal and emotional process, and while the law provides a framework for division, it's the unique circumstances of each case that dictate the path forward as you're working your way through it. or arguing your way through it. Please be a pragmatist. So what's the point in all this? Well, dividing up the debts in a Georgia divorce is a multifaceted process that demands careful consideration of each party's financial situation. From distinguishing between marital and separate debts to navigating the complexities of joint accounts, every decision in a divorce carries weight and implications for the future. So remember, there's no one-size-fits-all solution, and the key lies in achieving an equitable division that aligns with the principles of fairness and justice, because that's what the court's looking for. So if you're going to get there on your own, make sure it's fair, or the court's going to end up doing that. Hey, thanks for watching this video. I hope you found it helpful. Be sure to click subscribe, like, follow, whatever is appropriate for the platform you're watching it on, and turn on the alerts so you'll get notified when we post our newest videos. Please share these videos with people you care about who need to see this information. Feel free to repost them, and let's get this information out to people who really need to know about it. Also, leave us some comments. Let me know if you have any questions or suggestions for other topics, and let me know your thoughts. I really want to hear what you have to say. All I ask is that you keep it polite. Remember to join our Facebook group at Georgia Divorce and Custody and join in the discussion. And as always, I look forward to seeing you on the next video.